Disclaimer. I added in humor to hide how pissed off I am! Also, this video will be talking about adult issues and real medical issues. Q&A research or your religious views is not welcomed, only actual medical scientific studies and research. And any comments providing such BS will be deleted, or any dictatorial points of views from people who think they have the right to their partner's or anybody's body without consent. Thank you. Hello, my sweeties. I wish I was coming to you in a positive way, but at the moment, right now, women's rights are being taken away. But it's also being used to attack other groups' rights, i.e. transgenders.
A key way in which these two movements are linked is, in one way, very simple to explain. It's the same groups and the same groups of people. We know that groups such as the Family Research Council, the Heritage Foundation, and Alliance Defending Freedom have all been on the cutting edge of the anti-abortion movement for decades now. And they've just simply taken the tactics that they've learned from the anti-abortion movement and are now applying them to the anti-trans movement. So, for example, we are seeing doctors who provide gender-affirming care now being targeted by the right with demonstrations outside, with posters, with videos online, being doxxed online, for example. And it's also the case that we have to remember that for them, this is one fight. There is not a separation between the anti-abortion fight and the fight over trans rights. For them, they are essential in the vision of gender that for them is motivated and deeply rooted by the Bible. They feel that the United States is a white Christian nation, that it was ordained that way, both by God and by the Constitution, although the founding fathers disagree with them, but facts don't matter. And what they believe is that women having abortion, people being able to express whom they love through sexual orientation, and the ability to be able to live your true gender identity are all key elements in undermining white Christian America. And so for them, again, this is one fight. And this is not the way that progressives view this. They view trans rights as kind of ancillary, as sort of on the margins, as not being an essential fight, as something that, may be good or may not be good. But for the right, this is an essential fight.
I, as a biological woman, a single mother, have my entire life about to be turned upside down by the GOP. So I thought we would talk about the history of Roe versus Wade, the reason why abortion is a much needed medical procedure, and why it is so important that we do not allow its illegalization to happen. And yes, this video has been rushed due to certain circumstances.
Stop spilling the tea!
And drink the coffee! Bam, ba-dum, bum, bum, bam, bam, ba-dum, bum, bum, bam, coffee! Bam, ba, 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 coffee! Dun, 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 coffee!
In about 6 months, probably this decision will come down in June of next year. In about 6 months, Republicans in 30 Republican-controlled states will probably lose their right to access to an abortion. And it's important to understand that the Supreme Court doesn't give rights or grant rights. What it does is it recognizes rights and then defines the extent to which they can be infringed upon by our government. Right? Yes, you have the right to own a gun, but you don't have a right to own a sawed-off shotgun or a machine gun. Yes, you have the right to walk around in public, but you can't walk against a red light, or you can drive in public, but you can't drive through a red light. In other words, what the courts do is interpret the laws in ways that in many ways restrain our rights. But generally, the courts do not take away our rights. To the best of my knowledge, this has only happened, at least with any substance, once in the history of the Supreme Court, and that was in 1896 in Plessy versus Ferguson, where the Supreme Court took away the rights that had been granted to African Americans with the 13th, 14th, and 15th Amendments to the Constitution and through the process of Reconstruction, took away those rights to vote, public assembly, to due process, basically stripped African Americans of all of the due process rights for the next 50 years. And then the Supreme Court restored those rights in 1954 with Brown versus Board. But that's about it. But here we have a case where the court is planning on taking away constitutional rights, specifically from women.
Abortion was illegal until a landmark case in Texas, Roe versus Wade, on January 22, 1973, when the Supreme Court struck down a Texas statute banning abortion. Before abortion was legal, according to History.com, quote, until the 19th century, abortion was legal in the United States before quickening the point at which a woman could first feel movements of the fetus, typically around the 4th month of pregnancy. Some of the early regulations related to abortion were enacted in the 1820s and 1830s and dealt with the sale of dangerous drugs that women used to induce abortions. Despite these regulations and the fact that the drugs sometimes proved fatal to women, they continued to be advertised and sold. In the late 1850s, the newly established American Medical Association began calling for the criminalization of abortion, partly in an effort to eliminate doctors' competitors such as midwives and homeopaths. Anti-abortion began due to the increase of immigration. Many feared declining birth rates among the whites. Basically, the white population was scared to be the minority. Sounds familiar. Starting in 1869, led by the Catholic Church, banning of abortion at any stage of pregnancy, and in 1873, Congress passed the Comstock Law, making it illegal to distribute contraceptives and abortion-inducing drugs through the U.S. mail. By the 1880s, abortion was outlawed across most of the country. With the women's rights movement during the 1960s, court cases involving contraceptives laid the beginning groundwork for Roe versus Wade. Quote, in 1965, the U.S. Supreme Court struck down a law banning the distribution of birth control to married couples, ruling that the law violated their implied right to privacy under the U.S. Constitution. And in 1972, the Supreme Court struck down a law prohibiting the distribution of contraceptives to unmarried adults. Meanwhile, in 1970, Hawaii became the first state to legalize abortion, although the law only applied to the state's residents. That same year, New York legalized abortion with no residency requirement. By the time of Roe v. Wade in 1973, abortion was also legally available in Alaska and Washington. End quote. Meet Norma McCovey, the woman that we can all thank for her rights to have an abortion. In 1969, Norma, at the time in her early 20s, was seeking to terminate an unwanted pregnancy. By this point in her difficult circumstances, she had already given birth to 2 children and given them up for adoption. At this time in Texas, abortion was legal only for saving a woman's life. I will dive deeper into this later. Quote, while American women with the financial means could obtain abortions by traveling to other countries where the procedure was safe and legal, or pay a large fee to a U.S. doctor willing to secretly perform an abortion, those options were out of reach to McCovey and many other women. As a result, some women resorted to illegal, dangerous, back alley abortions or self-induced abortions. In the 1950s and 1960s, the estimated number of illegal abortions in the United States ranged from 200,000 to 1.2 million per year, according to the Guttamacher Institute. End quote. This kind of sounds a little familiar, doesn't it?
What I wanted to do is understand how the abortion rights movement is reckoning with this moment of loss. So I spoke to more than 50, experts, abortion providers, activists, people involved in this struggle in one way or another. And a really important thread that emerged is that, in the course of basically since Roe v. Wade happened, the white-led groups that have had the bulk of the resources and political capital within the abortion rights movement have often ceded ground and chosen to fight through the courts and fight a more defensive strategy that has really surrendered at many key moments the rights of women of color, Black women in particular, poor people, those whose rights and access were sort of the first to disappear in this incremental battle over abortion rights. And that really starts in 1976 with the passage of the Hyde Amendment. Representative Henry Hyde, who brought it forward, said he wanted to restrict abortion for everyone, but alas, all he had was the Medicaid bill, and so he would have to just restrict it for poor people on Medicaid. And so the Hyde Amendment, which banned federal funding of abortion and eliminated access to abortion for most people who are on Medicaid in most states, was, there were attempts to oppose it at the time, but really what ended up happening is that the Democratic Party and abortion rights groups, a lot of which were white-led at the time, sort of were willing to trade away access for poor people for other political priorities. And so the Hyde Amendment, the ban on federal funding of abortion, sort of became accepted precedent and an accepted and routine part of the budget process for many years. And
after failing to obtain an illegal abortion, McCovery was referred to two Texas attorneys who wanted to challenge the anti-abortion laws. These lawyers were Linda Coffey. Hello, my last name is Coffey. What's our family coffee makers? And Sarah Weddington. Yep, I read that right. Within the court documents, Jane Roe was put in place of Norma McCovery's name. I am assuming for privacy reasons. Henry Reid was the district attorney in Dallas County where the lawsuit and McCovery lived at the time. Linda Coffey and Sarah Weddington filed the lawsuit on behalf of their client in 1970 on behalf of not only McCovery, but for other women as well, saying, quote, who were or might become pregnant and want to consider all options, end quote. In June 1970, quote, a Texas district court ruled that the state's abortion ban was illegal because it violated a constitutional right to privacy, end quote. However, Wade continued to prosecute doctors for performing abortions. During this time, McCovery gave birth to her third child and placed that child out for adoption while her lawyers appealed to the U.S. Supreme Court. Quote, on January 22, 1973, the Supreme Court, in a 7-2 decision, struck down the Texas law banning abortion, effectively legalizing the procedure nationwide. Procedure, we are talking about abortions, by the way. In a majority opinion written by Justice Harry Blackmun, the court declared that a woman's rights to an abortion was implicit in the right to privacy protected by the 14th Amendment. The court divided pregnancy into 3 trimesters and declared that the choice to end a pregnancy in the first trimester was solely upon to the woman. In the second trimester, that the government could regulate abortion, although not ban it, in order to protect the mother's health. And in the third trimester, that the state could prohibit abortion to protect a fetus that could survive on its own outside the womb, except when a woman's health was in danger, end quote.
The court ruled in 73 that women have a right to an abortion in part because of the liberty right defined in the 14th Amendment, that, no state shall, and specifically says no state shall, take away any person's right to liberty unless through due process, unless it's done by an act of law. And this is what they're trying to do. They're trying to create an act of law here. And the Fourth Amendment privacy right, which, the Fourth Amendment basically says you have security in your personal effects. And that was the woman's privacy right to keep an abortion between herself and her physician.
The Supreme Court, quote, held a woman's rights to an abortion was implicit in the right to privacy protected by the 14th Amendment to the Constitution, i.e., our Constitution and the 14th Amendment as a Constitution gives us the right to an abortion. The legacy of Roe v. Wade changed many women's rights and abilities of choice. Many states have tried to impose restrictions to weaken abortion rights, and many Americans remain divided on whether or not to support a woman's right to the choice of an abortion. something that we are currently seeing coming to a head once again right now as we speak.
So what's next? Well, next up on the GOP agenda is stripping women of political and economic power by banning most forms of birth control. You'll recall, those of you old enough to remember what I'm talking about. And the birth control pill was approved by the FDA in 1959. It was legal, but for the next 2 years, it was only used for things like irregular menstrual periods. In 1961, it was approved for contraception, but it really wasn't until 63, 64 that it started being used in a big way as a birth control pill. There was, people had doubts about, is it safe? Is it going to cause cancer? All that kind of stuff. And, but now we've got it. Now we've got birth control pills, and birth control pills and IUDs are up next.
So, what about the medical side of abortions? Is there an actual medical reason we could need an abortion? Actually, there are several. Unfortunately, whether or not we wish to admit it, pregnancy isn't all roses and rainbows. Not all women are lucky to be as fertile as myself, and are not always lucky to have had an easy pregnancy and or birth such as myself, which I am grateful to have had 2 easy pregnancies with little to no complications, but not all women are lucky. Women can struggle becoming pregnant and even being able to carry to full term. Miscarriages are very common, and an abortion is needed in order to remove the unborn and unfortunately no longer alive. What is scary is if we lose Roe versus Wade, women who struggle with pregnancy and struggle with carrying to full term may be facing legal actions for their body's inability to carry to full term, something that is not within their control. There are also other health issues that may lead to a woman having to make the difficult choice of her life versus the life of her unborn child. All this gets lost in the chaos when abortion is brought up. Yes, rape happens, and yes, women can get pregnant from rape. And if you are not able to have access to things to prevent said pregnancy, such as Plan B, or end it, such as abortions, and you are forced to carry this child, who is a child of your rapist, to full term, this causes many psychological difficulties, such as rejecting said child, and the child may grow up in a home where they feel rejected and never get the love from their parental figure, i.e., their mother. Yes, you could put the child up for adoptions, but they have proven time and time again that foster care also has its own issues. But this is not the only reason women may have to have an abortion. Returning back to my previous statement, which is often lost in the chaos of women having a one-night stand and having an abortion after. This is a layered topic and cannot be seen through a narrow lens like it currently is. In Tommy's article, pointed out that, quote, many women and couples told us they dislike the use of the word termination to describe their experience because of its association with termination of unwanted pregnancies. They also feel it implies that they had more choice than they realistically had. Try to remember that it is just a medical term, end quote. Tests can show that a baby may have serious medical problems such as generic or structural conditions. Chronicus villus sampling, which diagnoses things such as Down syndrome and cystic fibrosis, as early as 10 weeks. However, fatal anomalies cannot be found until after the 20-week mark, such as lethal fatal anomalies, which means that the fetus will certainly die before or shortly after birth, leaving the mother having to make the choice to terminate, more often than not, a wanted pregnancy. Quote, a study of maternal fetal medicine, MFM doctors, specialists who manage pregnancies with fatal anomalies, found most agreed that termination of pregnancies due to a lethal fatal anomaly should be allowed in all circumstances, 76%. The majority, 75%, discussed abortion as a management option soon after diagnosing a lethal fatal anomaly, but services for terminating pregnancies in these scenarios are limited. Only 40% of the MFMs worked at healthcare centers offering abortions past 24 weeks for lethal fatal anomalies. An additional 12% knew of available services within the 50-mile range. Other factors come into play, such as preeclampsia. I am sorry if I am horribly mispronouncing so many of these medical terms. A condition of high blood pressure and signs of damage to another organ system, often the liver or kidneys. Cancer and intrauterine infection, cryoanomalies, often in conjunction with premature rupture of the amniotic sac, PPRON, basically the sac that helps keep the baby alive. These conditions can lead to the mother having to make the choice of termination for her own health issues. All these are protected under Roe v. Wade as we speak, but will no longer be protected if we lose it. The American College of Obstetricians and Gynecologists and Physicians for Reproductive Health, a group of physicians providing health care for women and group that strongly advocate for quality health care for women, released the following statement, I believe, in September of 2018. The science of medicine is not subjective, and a strongly held personal belief should never outweigh scientific evidence, override standards of medical care, or drive policy that puts a person's health and life at risk. Pregnancies imposes significant psychological changes on a person's body. These changes can exacerbate underlying or pre-existing conditions like renal or cardiac disease, and can severely compromise health or even cause death. Determining the appropriate medical intervention depends on a patient's specific conditions. There are situations where pregnancy termination in the form of abortion is the only medical intervention that can preserve a patient's health or save their life. As physicians, we are focused on protecting the health and lives of the patients for whom we provide care. Without question, abortion can be medically necessary.
For example, in Texas, Senate Bill 8, which puts that $10,000 bounty on the heads of people who help a woman get an abortion, that's the one that gets all the attention. But Senate Bill 4 also passed. And Senate Bill 4 is particularly insidious. It makes it a crime for a woman to be prescribed any of these abortion-inducing drugs more than 3 weeks after missing a period. Mifeprex, which works up to 70 days after the last menstrual period, Cytotec, which works up to 13 weeks of pregnancy, and methotrexate, which works up to 9 weeks of pregnancy. A physician can go to prison if they prescribe these after the 3rd week after a missed period. Lauren Windsor, the reporter, asked Texas Governor Greg Abbott straight up if he wanted to try to ban all birth control pills in the state of Texas. And he said it was still possible, which is step 2 on the Republican Party's war on women. Rick Santorum famously ran for president in 2012 on a platform. He was just right up front about it, Rick Santorum, that he wanted to ban birth control pills because hormonal birth control was actually a form of abortion. This is what's called personhood. These personhood bills define life as beginning at the moment of fertilization, when the sperm crawls up the fallopian tube and intersects an egg and fertilizes that egg. That, according to these personhood bills that have been introduced and at the federal level, none have passed so far. But there's a whole bunch of them waiting for Roe v. Wade to get knocked down. They define personhood. They define that fertilized egg as a person. Now, this is 3 days before it implants in the uterine wall, and and forms a placenta and begins the process of gestation. So, bottom line here, at least one legislative branch of the following states have already passed one of these personhood laws, which would outlaw IUDs, which prevent implantation, and would outlaw all hormonal birth control pills, which prevent implantation. And the states that have already passed these through at least one branch of their legislatures are Montana, Kansas, Virginia, Tennessee, North Dakota, Arkansas, Mississippi, and they have been introduced, but not yet passed, in Ohio, Georgia, Maine, Texas, South Carolina, Oklahoma, Iowa, and in the United States Congress. There's a group called the Personhood Alliance. They have affiliates all across the United States. Catholic leaders have signed on with this. Multiple hard-right evangelical groups have signed on, denominations have signed on to this as well. I mean, there's a long history here of men controlling women.
In conclusion, I cannot help but think of a quote by a very respected woman to her husband in a letter. Don't forget about the women. Hey guys, please don't forget to like and subscribe for more content and to help with the algorithm. Also, don't forget to comment your own personal experiences and stories, and if you have any ideas for future videos, you can always reach out to me here on my DMs and my social media accounts or my email. I also do a lot of my updates for my channels on those accounts too, so you can always know what I am up to.